కేసులు బద్దలవుతున్నాయి, బౌండరీలు దాటుతున్నాయి. పూర్తి వివరాలకు చదవండి రేపటి సాక్షి దినపత్రిక.
Welcome to Sakshi TV's special immigration talk show with attorney Prashanthi Reddy. Please note that Sakshi TV now has 5 immigration shows every week. On Mondays with Somireddy Garu, on Tuesdays with Kaveti Garu, on Wednesdays with Prashanthi Reddy in English, on Thursdays with Chand Parvatneni, and on Fridays with Badu Nindra. Please tune in to ask your questions. If you are an immigration attorney and would like to join our special shows, please email us at usa@sakshi.com or call us at 866-725-7441. Before we begin the show, please note that the information provided on this show is not for legal advice and for general informational purposes only. Sakshi TV or its agents will not be responsible for the use of information. If you need any advice, you can definitely contact the attorney directly. For today's show, we have an immigration attorney and lawyer, also the founder of Law Officers of Prashanthi Reddy, one of the leading firms in USA. They deal with a wealth of different topics from H1Bs to F1 to investors and whatnot. For more information, definitely log on to www.reddyesq.com. So without any further delay, let us welcome the founder herself, Ms. Prashanthi Reddy. Welcome back, Andy. I hope you're doing well, Prashanthi Reddy garu.
I'm doing well, Andy. Thanks for asking, and good to be on the show again.
Yes. So Prashanthi Reddy garu, now that we've been doing this show for a while, I kind of want to get into what you do and what does your law firm provide to the viewers watching the show right now.
So we are an immigration law firm, full service immigration law firm. We do all kinds of immigration cases, from family to employment-based, H's, L's, TNs, employment-based, family-based categories, B2 extensions, F1s, everything, you name it. We take care of everything. Our offices are in Manhattan, New York, and I have over 25 years of experience, and happy to share that I have been listed as the top 10 New York attorneys by the Forbes magazine recently. So that's a good landmark, I think, for me. And always happy to serve our Telugu community, and always have been.
Congratulations on that, Ms. Reddy. And I think with that, we can definitely continue with today's topic. So today, it is quite an interesting topic, actually. Today, we'll be talking a little about the dependence of the H1B and the F1 visa. So, Ms. Reddy, with whom do you want to start, F1s or the H1Bs?
You choose.
I think I'll go with the F1, actually. So my first question to you are, Ms. Reddy, what are the dependents of F1 called? And also, what are some restrictions that the F2, who are again the F1 dependents, what are some restrictions that these people generally face when they are in USA?
So the F1 dependents are called F2s, and they can include spouses as well as children of students. So F1s, we know F1s means that they are students. They're in a student status. They have I-20s, and they are following a full time program in an accredited university in the United States. They're allowed to bring their family, and that's how we have the F2. The F2, they can go to school, and we see a lot of F2 children attending school, attending high school, elementary school, colleges as well. And the spouses also can attend colleges as long as they're in status. However, F2s cannot work unless they have independent employment status. So that's something to keep in mind.
Yes. Now, Ms. Reddy, I kind of wanted to know that, let's say somebody, again, F1 is much more powerful than somebody who has an F2. So is there any chance that people with F2 can change their status from the F1 or the H1Bs?
Yes, the F2 can change status. If you are an adult, you can change from an F2 to an F1. If they are independently pursuing school on your own and you get an I-20 from an accredited university, you can definitely change your status to an F1. And of course, there are advantages of being on an F1 rather than studying on an F2 because you get OPT, CPT, etc. which you wouldn't get if you were on F2 and studying as a student. So definitely an advantage to be on your own F1 status. You could also change to a H1, provided you qualify for a H1 and you file within the cap and you get selected in the lottery. You can also file for a change of status to any other status, such as a visitor's visa, say your spouse loses their F1 status for some reason, or, unfortunately, say you get divorced or you're getting divorced, in order to, um, kind of remove yourself from being dependent on your spouse, then you could change to an F2, to a B2 as well in the interim, because it might be difficult to change to an F1. You have to get an I-20, admission, and school starts at a certain time. They don't start year round. So B2 is also something that is possible for F2 uh, dependents.
Yes. Now, Ms. Reddy, I kind of want to understand that post, let's say somebody's on F2 and they got their F2 status when they were probably 13 or 14. And then once they've, crossed the age or once they're over 21, how can these people transition their F2 to F1 or H1B?
Yes, so we know that in order to be a dependent child, whether you're in F1 status or you're on H4 status, you have to be under 21 years of age. So before you hit that mark of 21, you should file a change of status to some other status, independent of your parent status. And depends on what your situation is. If you're going to school, then you should just change to an F1 status. Maybe you're an undergrad, you're pursuing an undergrad program, then you get an I-20 and join an accredited school, register in CVIS, pay the tuition fee, file a I-539 petition for a change of status from an F2 to an F1. The good thing about the I-539 change to an F1 is there's also premium processing, so you could expedite your F1 change of status process. Otherwise the F1 change of status, F2 to F1 takes sometimes 12 months, sometimes 18 months. And by the time you do that, your school might have already started, and then, you might have to defer to the next semester. So that's problematic often. So it's good to do a premium processing, and so that you'll be able to, be on time for the next semester.
Yes. Ms. Reddy, you initially kind of mentioned that people with F2 can't really work. They don't really have work authorization. So is there any chance that F2s can, apply for work, or is there any certain way that they will have to follow to get their work authorization?
Work authorization is for an F2, it's not possible, unfortunately, to get work authorization. You have to be on a H4 status to get work authorization. So unfortunately, F2s cannot get work authorization, and there is no way of getting it unless you change status to, a H1, or you get your own F1, and then you can apply for CPT if you're still in school, or apply for OPT or STEM OPT. But otherwise, it becomes a problem to, get to work on an F2. You have to get independent work authorization, and unlike the H4, there is no EAD filing possible for an F2. Hopefully it'll come soon, but right now we don't have it.
Yes. And I think, Ms. Reddy, a lot of people with F2s do unfortunately, try to get some work, probably like a babysitter, or, some jobs which are not really, in the system. So, Ms. Reddy, can you just tell our viewers who might be doing this stuff, what kind of consequences can they face from the US government if they are caught?
Well, you'll pretty much be out of status because you're not work authorized and you're working without, without authority in the US, because you don't have a work authorization document. You are considered to be out of status. So if someone were to come to your workplace, show up there, ICE can come pick you up and then deport you, put you in removal proceedings. Or if they usually find out when you apply for a visa, or more often than that, they find out when you're traveling. There are so many instances in which people are, when people just go for vacation and they're coming back, and then when they come back, they notice that, they ask them for their phone or they ask them for their laptop. And they have everything, the whole history in their laptop, including their pay stubs. So that is problematic, and a lot of people have been sent back because of that. And not only have they been sent back, but they've been given a bar for 10 years, which means that they can't come back for 10 years. They can't apply for a visa. Even if the officer wants to give them a visa, the officers cannot do that. So
Yes.
it's important to be very, very prudent, to follow the rules, not work unless you have the authority to work.
Yes. And I think the viewers would be very interested, you being one of the top law firms. Have you personally dealt with any of these F2 visa complications, which are super messed up, but you still kind of managed, or maybe like a story to the viewers watching?
Yes, we do often hear a lot of sad stories of people who were, removed from the airport itself. And I think last year there was a spouse, a young couple, the spouse unfortunately worked, and unfortunately for her, it was a random check, and they checked her cell phone. She was carrying her laptop, and I always tell people, don't carry your laptop, number one, in your hand luggage. Don't carry your cell phone. If you're carrying it, delete your social media. Don't put unnecessarily stuff, your whole life history on your laptop, right? Clean it up. So, you never expect that something like that will happen to you. You always think it happens to someone else and it won't happen to you. You never know, though, right? Though the incidents are few and far between, if you look at the number of incidents compared to the number of people traveling, it's a very, very low percentage, but it still happens, and it could happen to you, right? You never know. So she arrived at JFK, and as I said, they searched her laptop. They found information that she worked at a gas station, and there was some information with reference to pay stubs. I don't even know. I don't even think it was pay stubs because she was being paid cash. But there was something else in it which indicated that she was working, maybe email exchanges, etc., showing that she was working. And then they immediately they interrogated her, took her in for secondary inspection, um, made her sign a written statement that she agrees to withdraw her application, and then sent her back. And unfortunately, even though she voluntarily agreed to withdraw her application, they still they still issued the removal proceedings and a bar, and the bar was for 10 years. And she had to leave, and her husband was here, her child was here, unfortunately, and she was separated from her family. And then she applied for a visa again, and it was rejected because of the bar. Then she filed a waiver. There is a non-immigrant visa waiver that can be filed based on the fact that she has a minor child and her spouse is in the US. We helped her get that waiver by preparing a memorandum showing that she's never she's been a good citizen. She has always maintained her status, never except for that one incident which she did without realizing it. And so we put a story and filed a memo, and luckily enough for her, the officer agreed to issue her the visa. But that's one in many. There are many instances where they have not issued visas, and they don't even look at that non-immigrant visa waiver that you submit. So I would urge people to be very, very careful when you're on a L2 visa and not, or an F2 or a H4, and not work if you're not authorized.
Yes. And I think, Ms. Reddy, I kind of wanted to ask, so let's say somebody with F2 want to pursue some higher education. So what are the limitations compared to an F1 visa? Can they legally apply for higher education? What's the whole scene in this?
So yes, they can apply and go to school. As I said, they can right from primary school to university. They can enroll in a program, but the benefit or the disadvantage of being in an F2 is that you can't work. You're not after you finish your school, you're not authorized for OPT. While you're in school, you're not authorized for CPT. Um, so that's a problem. So it's better than if you're a full-time student anyway, and you're going to school and you have a program which issues an I-20, that you get onto your own F1 status. And the other advantage of being on your own status is you're not dependent on your spouse's status, so all your eggs are not in one basket, right? So one person's status doesn't determine everybody else's. So you have more options when it comes to, status or maintenance of status. So I always advise people who are studying on an F2 to, get their own F1 status.
Yes. And I think with that, now that we have halfway done with our show, Ms. Reddy, let's go into the H1 dependent. So, Ms. Reddy, what are some current rules that the H1 dependents are supposed to follow now, and how different is it from a H1B and their dependents?
So a H1 dependent, if we're only talking about the H4 status, pretty much their status depends on their spouse's status. So if the spouse is maintaining the status, they are maintaining status as well. But you also have to remember that the H4s have a separate I-94 and they have to extend their I-94. Oftentimes I see that spouses think that if the I-94 of the H1 is extended, automatically their H4 gets extended. It doesn't work that way. You have to file a separate application, an I-539 application to extend your H4 when you're extending the spouse's H1. And employers also sometimes forget or don't realize that they have to file a separate application for the spouses. So this is for all of you out there. Please remember that when there is a H1 application being filed, if you have to always look and see if the H4 I-94 has expired or not. If it hasn't expired, you don't necessarily have to file the H4 extension along with the H1. But if it is expiring, then definitely you have to file and maintain your I-94 independent of your spouse's I-94. But remember, if your spouse is not working, then you are out of status as well. And I would suggest in some instances, even if your H4 I-94 is not expiring, say it's expiring 6 months later or 8 months later, but your spouse is applying for a H1 extension, I urge you to file your application along with your spouse's, because USCIS adjudicates H1 and H4s together, and H4 EADs, H1s, H4, H4 EAD. They'll adjudicate all three applications together. And if the H1 doesn't take that long, it takes 4 to 6 months, and there's premium processing available. But if you file a H4 or H4 EAD separately, it takes 10 months, 12 months, sometimes 18 months. So this is a thing that not many people know unless you're in the field. So I urge you to file both applications together whenever it's possible.
Yes. And Ms. Reddy, when I was kind of researching about the H4, there's something called as the H4 EAD work permit, and apparently it's a little controversial now. So can you please tell us how is this affecting the H1B families out there?
Yes, sure. So as I said, some H4 dependents can work, and the H4 dependents that can work are those dependents whose spouses have an I-140 approved. I-140 is an immigrant petition which is filed the second stage of a green card. After the labor cert is approved, the I-140 is filed. So once that is approved, your dependent spouse can work on a H4. In addition to that, your H4 can be extended and continuously extended as long as you maintain your H4 status, which means that as long as you're extending your I-94 and you don't let it expire. And also your spouse continues to maintain their status by working for the employer as well as, maintaining their I-94 as well. The controversy is that what was happening is that the H4 extension is given only for a year. The H4 EAD is given only for a year. And when the EAD expires, the dependents had to stop working. And the EAD extension was taking, as I said, 12 to 18 months if it's not filed along with the H1. But since 2022, from 2022, they said that for some categories of EADs, they could work automatically, first for 180 days, and then they extended it in 2022 to 540 days, I believe. The time that you can work automatically, as long as you just file a EAD extension while it's pending, you can continue to work. So there's no gap in employment. So as of April 2024, that is this year, they again extended that to 540 days and included the H4 category also in it. So that was good news. So now, even if your EAD is bound to expire every year, and their processing times are long, and you can't always file your H4 along with your spouse's H1 because the spouse may not need to file the H1. But the good news for them is that there's an automatic extension for 540 days, as long as you file the EAD before the expiry of your previous EAD, and your EAD was filed between that 2022 and October of 2025. You get an automatic extension of 540 days, but one caveat is if your I-94 expires sooner than the 540 days, then your EAD is extended only until the expiry of your I-94. So you have to always make sure your I-94 is valid.
Yes. And Ms. Reddy, how can the H4 dependents, the H4 transition to an H1B, and what are some complications that you, as an international immigration attorney, have seen generally?
So with reference to the change of status from a H4 to H1, it is very common. And often H4 spouses are qualified, and they're a good resource for a lot of these IT consulting companies and IT companies to file their H1s, and they're available in the US. And some of them are already working on H4 EAD, but would like to go on a H1 so that they don't have to extend every year. And they're available for interviews, so they're a good resource for people looking for new resources. And the only issue with filing for a H4 to a H1 is that you have to file under the cap. If you've never been on a H1 before, you have to file a change of status by first filing registration in March when the H1B lottery opens up. And if you get picked in the lottery, only then will you be able to file your change of status application from H4 to H1. You have to ensure that your H4, you remain in H4 status until the start date of your H1. And if it's a new H1, then it'll only start October 1st, even though you file it in April. You're filing it 6 months in advance. So you have to ensure that you're in H4 status until the date that you're until October 1st, the validity period of your H1. So that's something to keep in mind. And of course, like anyone else, you have to qualify for the H1, and your company has to qualify to file a H1 for you.
Yes. Ms. Reddy, I kind of wanted to understand, let's say, unfortunately, the H1, if there is a H4, and let's say that H1 spouse or some dependent, they have lost their jobs. So let's say the H1 has lost their job. What are some consequences that the H4 dependents can face?
That's actually a good question, because the H4's status depends on the H1, as I was saying. But for the H1, they have a 60 days grace period right now, correct? As of a couple of years back, USCIS has granted a 60 days grace period for all those people who are on a H1. If they lose their jobs for whatever reason, then they can stay in status until 60 days, and within the 60 days, if they find another job, they can then file for a transfer. So that 60 days grace period will then allow the H4s also to stay in the country because their status is depending on their spouse status. So if their H4 is not expiring, they don't have to do anything. And as long as the spouse, H1 spouse, applies for a H1 transfer within the 60 days grace, they're good. There's nothing that needs to be done. If they're not able to do that, then they have to change status along with their spouse to a B2 or an F1, or they have to leave the country.
Yes. And also, Ms. Reddy, can the H4 dependent children attend public schools or get higher education? If yes or no, what are some legal complications or the legal laws that they must be knowing?
So it's pretty similar to F dependents. The H4 dependents can go to school from primary school to college, and they cannot work. Children cannot work, but spouses of H4 dependents of H1 can work. But if we're talking about going to school, then they can absolutely go to school. They can change also to an F1 if they want to become full-time students or they want to get the benefit of working on OPT, etc. An important condition to be met is that the children should be under 21 years of age, and before they turn 21 they should file for a change of status to an F1 or a B2 or leave the country.
Yes. Yes. Ms. Reddy, and finally, is there anything that you want to say to the H4 dependents who are watching the show, and what are some legal complications that they can get into if they are kind of misusing anything?
Yes, so as like any other non-immigrant status, if you are not a US citizen, there will be consequences if you don't follow the law. It's not just immigration laws. Of course, if you don't follow immigration laws, you'll be removed, and we discussed that with the F1 example. But also, you will, if you get into some trouble with the law, if you commit a crime, then you are automatically will be removed from the country. Excuse me, especially if it's a felony. If it's a misdemeanor, you may not be. There are some exceptions. For example, if it's a misdemeanor and if it's your first misdemeanor, there's a petty offense exception, so you may be okay. But any other thing, any other crime that you commit, you will be automatically removed from the country, especially if it's a felony. And if you leave, you cannot come back because they won't give you a visa.
Yes. And I think with that, Ms. Reddy, we'll have to end today's session. It was very informative. Thank you so much, Ms. Reddy, for giving your valuable time with us. Thank you again for the viewers for tuning in. You're watching Sakshi TV with me, Shivani Raj.